In my view, obedience of court orders is one of the tenets of the rule of law, and contempt of court would not be countenanced in a constitutional democracy such as ours, where the rule of law expressly stated in Article 10 to be one of the values and principles of governance. It is the responsibility of the court to ensure that executive action is properly exercised. That Parliament intended that the High Court has the responsibility for maintenance of the rule of law, that there cannot be a gap in the application of the rule of law, that the court must at all times embrace a willingness to oversee executive action and to refuse to countenance behavior that threatens either basic human rights or the rule of law. The instant case is a cause of anxiety because of the increasing trend by government ministers to behave as if they are in competition with the courts as to who has more muscle in certain matters where their decisions have been questioned in courts. Courts, unlike politically minded ministers, are neither guided by political expediency, popularity gimmicks, thirst champing, nor competitive streaks. Courts are guided and beholden to law and to law only. Where ministers, therefore, by their actions step outside the boundaries of law, courts have the constitutional mandate to bring them back to track, and that is all the courts do. Some members of the executive are behaving as if they are law unto themselves, and that the positions they occupy are their birthrights. They must know that the said positions are courtesy of the Constitution, which they must bow to, however powerful they are. And I must send a strong message to those who are intent in disobeying court orders. Such conduct will not be tolerated no matter the status of the contempt laws in society. When persons in authority themselves set out to disobey court orders with impunity, they must remember that they are sending wrong signals to ordinary Kenyans, and that it is proper to disobey court orders with impunity, which is a recipe for chaos. In this case, it is clear that the courts have been left babysitting its orders, while those whom the orders are directed are carrying on their business unperturbed. That state of affairs cannot be permitted to continue. Those who disobey court orders must be made to answer for their actions or inactions. In other words, there is no immunity from impunity. This is what I would call the lifting of the veil of executive inscrutability and inoculation. This court cannot just fold its arms while the respondents continue to catwalk on its orders. In the premises, I make the following orders. First, second, and third respondents have by their conduct been contemptuous of the orders of this court, and they are convicted accordingly. The said respondents will appear before this court tomorrow at 10 a.m. for sentencing and further orders. In default of their appearance, this court will proceed to mete out appropriate sentences, their absence notwithstanding. It is hereby directed that the petitioner is not under any circumstances to be removed from the jurisdiction of this court. Instead, the petitioner is to be unconditionally released forthwith to appear before this court tomorrow at 10 a.m. This order binds not only the respondents, but also the officers under them in whose custody the petitioner has been placed. The petitioner's lawyers are to be granted access to the petitioner. I, however, direct that unless the petitioner is released forthwith, said respondents will not be granted a right of audience by this court tomorrow, and those will be the orders for now.